Peace and blessings. It's Monday, October the 21st, the year 2019. I have in front of me the 29-page resentencing memorandum from the United States. So this will be a 29-page document that's written by the prosecutors, and it'll be their view on what should happen to Schaeffer Cox at resentencing. The United States Attorney at the top is Brian Schroeder. I might use his image on this video, so you'll see the new player. I guess they're bringing in somebody besides Stephen Scrocky to prosecute Schaeffer Cox. You've also got Stephen E. Scrocky, and we know what a liar he is. He's been caught in several lies, one of which is that you can look through all the evidence and you'll never find any death threats from Bill Fulton or Aaron Bennett, and we found evidence of both. So Stephen Scrocky is a known liar. How do you know that Stephen Scrocky is lying? If he's moving his mouth, he's lying. You got the address and phone numbers for Stephen Scrocky along with his email address. If you want to email Stephen Scrocky, it's stephen.scrocky, SKROCKI at usdoj.gov. It's amazing how these people even go to sleep at night, but the Bible says that if you and I do some wrong to somebody, we have a hard time going to sleep, but these people deviseth evil upon their beds. In other words, they need to do wickedness in order to get a good night's sleep. So they can't go to sleep until they do wicked. And that certainly fits the bill when talking about Stephen Scrocky, because he is an incredibly wicked man who operates under the title of an assistant U.S. attorney. He has been the face of the prosecution against Schaeffer Cox. We're about to read a document put together by him and Brian Schroeder, the United States attorney. In the United States District Court for the District of Alaska, United States of America, plaintiff versus Francis Schaeffer Cox, defendant, case number 3:11-CR-00022. If you want to download and read this document yourself, it will be on Year of Jubilee website. We have 2 pages for Schaeffer Cox. Just search for re-sentencing memorandum. United States resentencing memorandum. The United States files with the court a resentencing memorandum for defendant Francis Schaeffer Cox. The United States maintains, for reasons provided here and in the totality of the facts of the trial, that the sentence to be imposed upon remand by the Ninth Circuit Court of Appeals, particularly when compared to the defendant's post-conviction and current position on guilt and self-victimization, should remain unchanged. So, we have learned that the prosecution in Schaeffer Cox's case is saying that his sentence should remain unchanged. Well, that would be 26 years. At resentencing, the United States will be recommending that the court impose a sentence as originally adjudged, that being a sentence of 310 months. No downward departure for imperfect entrapment is supported by the facts nor warranted. A. Remand from the Ninth Circuit. Oral argument in this case was held before the Ninth Circuit Court of Appeals in Anchorage on August the 16th, 2017. 13 days later, on August the 29th, 2017, the Court of Appeals issued a non-published memorandum opinion reversing the conviction for solicitation of murder federal officials and remanding the sentencing. The United States does not contest that sentencing is essentially a new sentencing proceeding conducted without the dismissed count. B. The counts of conviction for resentencing. Defendant Cox is pending sentencing for the following counts of conviction. Count 1, conspiracy to possess unregistered silencers and destructive devices, hand grenades and silencers. For those of you that do not know, Schaeffer Cox got a letter out of the CMU prison where they manage his communication, and torture him and solicit the murder of Robert David Neal, who was Schaeffer's friend, he wrote a paper called On the Weapons Charges, where he covers the so-called weapons charges that we're reading now. Count 2, possession of unregistered destructive devices, hand grenade components for 4 hand grenades found in Cox's trailer. Well, the hand grenades were dummy hand grenades, and he might have had some JB Weld in his garage. Do you have JB Weld in your garage? Do you have like gunpowder somewhere around your house? And do you have a friend named Aaron Bennett who might have slipped you some, not fuses, but spent fuses? Because if you have all of those parts around your house, you might have the parts necessary to make a grenade, and they might charge you with possession of an unregistered destructive device. Count 3, possession of unregistered silencer. A silencer made by Cox found in the trailer. Well, do you have a rubber hose, like a water hose around your house? Do you have a can of shaving cream? Well, if you have a can of shaving cream and a water hose, you might be in possession of an unregistered silencer that you can stick on the end of the barrel of your gun that keep it quiet. Count 4, possession of an unregistered machine gun. Well, it's amazing that the Sten machine gun found in the trailer made fully automatic by Cox was not used for demonstration by Stephen Scrocky or Yvonne Lamouret or Joseph Bottini, because Schaeffer Cox's Sten machine gun did not work. It was a movie prop. Count 5, illegal possession of a machine gun, Sten machine gun. Count 6, making of a silencer, a .22 silencer made by Cox, found in Cox's trailer. Count 10, possession of an unregistered destructive device, 37 millimeter Hornet's Nest launcher and rounds. Count 12, conspiracy to murder federal officials, guilty as to Cox and Vernon. The bulk of Cox's sentencing memorandum concerns itself with the conspiracy to murder federal officials count and the concept of imperfect entrapment. It ignores the facts, statements, and the reasons for Cox's possession of silencers, the machine gun, hand grenades, and other recorded statements made by Cox establishing his intent to murder if one of his men were captured by law enforcement. He was taken into custody, or any member of his family taken into custody. These devices are part and parcel of the sentencing matrix, which should be given serious weight by the court at sentencing. Counsel for defendant have done an extensive job of focusing attention, as they should, on count 12, conspiracy to murder. However, the facts and circumstances of other 7 counts of conviction and Cox's own recorded statements should and must receive just as significant consideration as the facts giving rise to the conviction on count 12. Focusing alone on the acts and statements of Fulton and Olson misses the holistic, relevant conduct marks of sentencing. Indeed, for every statement made by Cox alluding to wanting to wait, there are just as many about hanging court employees so they dangle like wind chimes of liberty, non-opposition to sending heads in boxes, and other such statements. In the brief, the defense fails to mention the clear and present and real possibility that Cox was clear on 241. It would occur upon his arrest, an arrest of a militia member or of a member of his family, given Cox's provocations to the courts and law enforcement. The fact that a warrant was active for his arrest, the 241 scenario was something that could have happened at any time, a fact the defense brief ignores. Instead, it spends a significant amount of time on the Stalinist takeover of the United States and when that may or may not happen. That argument shifts the needle of the issue to the vacuous The reality was, and is, Cox's arrest was imminent, and if he was arrested, his loyal Lieutenant Barney, Sergeant Vernon, and possibly others were ready to take up his cause. Numbers of militia members were irrelevant. All it would have taken was one of these men to implement Cox's plan upon his arrest. One other trial established point requires mention and is relevant to Cox's argument of lack of intention. It concerns the Alaska State Troopers. Prior to his arrest on federal charges, Cox had occasion to be stopped by an Alaska State Trooper. After the stop, did Cox let the matter go? No! He located the trooper's address, wrote it down, and put the trooper's name on his list. These actions demonstrate just how serious a threat Cox was to the community, law enforcement, and others. I need to interject here that Schaeffer grew up across the road from this state trooper. They were neighbors, and Schaeffer felt comfortable going and talking to him. He wasn't trying to intimidate him at all. While Dr. Cunningham labels Cox a prepper, the label is a farcical one. A prepper prepares and passively awaits Armageddon on some natural disaster to occur safely, holed in a bunker or place of refuge. Here, Cox was open and notoriously instigating a clash with the courts and law enforcement, challenging them, backed by the strength of his militia, and thumbing his nose at the courts by holding a sovereign citizen court at a Denny's, exonerating him of physically abusing his wife. Well, how about he doesn't need to be exonerated of abusing his wife, physically abusing his wife, because he never beat his wife. His wife wrote a letter and we have photos. And who cares if he held court at Denny's? Is holding court at Denny's such a threat to the established courts, which are always prestigious, and they're enamored with judges who enter the courtroom in long black robes, and they have fancy regalia? If the court is so threatened by a Denny's courtroom hearing that was held by Schaeffer Cox, maybe they're a little concerned that they're not a legitimate court. He had been challenging law enforcement to take action on him for some time by public statements, showing up at arrest armed under his Liberty Bell program, advising troopers we could have you dead in one night, holding seminars advising citizens that criminal convictions were wrongfully and illegally obtained. The facts here are clear. Cox was no prepper, but was instead an instigator and threatening raconteur without any amusement. Raconteur, man, Stephen Scrocky and Brian Schroeder and Stephen Scrocky are using some very prestigious words. I don't know what raconteur means. We're going to have to look that up. Let me go back to the reading. They just threw me off with this fancy word here. My goodness. Where is it? There we go. RACONTEUR. They're so educated in the Department of Justice that the words that they use, we've got to look them up. Raconteur, a person who tells anecdotes in a skillful and amusing way. Wow. I can learn so much by reading the words of Stephen Scrocky and Brian Schroeder. Raconteur. While that was the then, the this is now, is just as problematic. Cox's public post and position, see Exhibits 1-26, made during his time of incarceration, reveal no change in Cox in the slightest. Let me read that again. Cox's public post and positions, see Exhibits 1-26, made during his time of incarceration reveal no change in Cox in the slightest. You see, what they want is they want Cox to be repentant and submissive and remorseful. They want to break the will of the liberty fighter that we know as Schaeffer Cox. They got to break him down. He's got to be on his knees. But they're upset that there is no change in Cox in the slightest, nor does it evidence any capacity or attempt to change. He continues to believe the United States conspired against him, defrauded him, concealed evidence, withheld evidence, has treated him unfairly in prison, and that he remains to this day an innocent man and political prisoner. Wow, how dare Schaeffer Cox hold on to the fact that he's been treated unfairly and he's been defrauded and the United States conspired against him. How dare Schaeffer Cox hold on to those beliefs? None of this warrants, nor should warrant, a downward departure based upon the reversal of the solicitation count, particularly as the court will see below. How dare Schaeffer Cox be upset that Stephen Scrocky lied to the jury and withheld exculpatory evidence and outright destroyed evidence? How dare Schaeffer Cox be upset that an FBI informant, a well-paid FBI informant, threatened to slit Schaeffer Cox's throat and bleed him out at his feet? How dare Schaeffer be upset at that? Part C, the past and current mindset of defendant Schaeffer Cox, an innocent political prisoner. The insert below is from Schaeffer Cox's Facebook page as of October the 16th, 2019. Well, that's only 5 days ago. A similar advert ran in the Fairbanks Daily News Miner newspaper in September of 2019. The page provides the court with the current mindset of this defendant. Up to $25,000 pledged for information leading to the exoneration of Schaeffer Cox. Help free an innocent man. Tell us what to FOIA, Freedom of Information Act. Tell us what to subpoena. Point us to a witness we should interview. Reveal what the prosecutor is illegally hiding. FreeSchaeffer.com. Everyone knows Schaeffer Cox is an innocent political prisoner. Even the prosecutor knows. That's why the judge ordered the prosecutor to hand over all the evidence that should be helpful to Schaeffer Cox. But this prosecutor has proven time and again that he'd rather lie to the judge than comply with an order like this one. That might cost him his case. That's why justice needs you. Support the judge's order. Fight corruption. Get paid for it. Contact Schaeffer Cox at gmail.com. This is some sort of flyer that's been put out by Schaeffer's supporters, and they're trying to make Schaeffer Cox be responsible for it, and they're putting it in his resentencing memorandum as if it is something to be used against him. How dare Schaeffer Cox offer a reward for information which would exonerate him? According to this still current post, Cox views himself as point, an innocent political prisoner. Point, an innocent man. Point, and beset by various other claims of wrongdoing against him on behalf of the prosecution, the FBI, and the United States. How dare Schaeffer Cox call into question the integrity and the prestige and the honesty of the prosecution and the FBI and the United States of America? How dare he call into question the integrity of the Department of Justice? How dare Schaeffer Cox call into question our integrity? He has offered up $25,000 pledged for information leading to the exoneration of Schaeffer Cox. The defendant also maintains an active blog site where various posts provide very clear views into the mindset about this case. Attached as exhibits 1 through 25 are blogs from the defendant's prison blog. These are broken down as follows. Exhibit 1, Holy Government, from July 28, 2016. In this post, Cox claims he is not mentally ill. He is not mentally ill and generally blames the government for his current situation. Exhibit 2, Inaction, after all, is action. May the 9th, 2017, quoted by Schaeffer Cox. Cox states that he's in a hole, sitting on concrete, naked, and alone in the dark. This blog is another multi-page denial of responsibility, blaming his predicament on Fulton, Bennett, J.R. Olson, the government, the prosecution, and others. Exhibit 3, Apples and Oranges, from SchaefferCox.com, from freeschaeffercox.com. This is essentially a complaint post-appeal against the prosecution. Footnote number 1, bottom of page 7. Apparently, Mr. Cox's fundraising efforts were so successful, he amassed $3 million, which were, according to the article on this hyperlink, absconded with by some former supporters and associates. And then a link is given, which Schaeffer Cox is suing the former supporters known as the board, who stole all of Schaeffer Cox's fundraising money. Exhibit 4 and 5, big quote, big win in court, end quote. February the 13th, 2019. This post claims the prosecution continues to hide evidence and solicits contributions to his legal defense fund. Exhibit 6, Conspiracy to be Schaeffer Cox. February the 26th, 2019. Cox again seeks funds for his legal defense under the guise of lying prosecutors who are hiding evidence. Exhibit 7, Dirty Conviction, August the 22nd, 2018, is a claim that his attorney-client visits were listened to by the FBI. This is untrue. None of Cox's conversations were recorded. Cox claims are false as to what he refers to were video without audio recordings that occurred at the Anchorage jail with several inmates and their attorneys. None of this occurred during Cox's tenure at the Anchorage jail, and even if it did, no sound was recorded. None of what Cox refers to in this post is true. Cox then again posts that his investigation was politically motivated, where the prosecutors knew he was innocent. Exhibit 8, Dollars for Downfall, July the 28th, 2017. In this post, Cox claims the prosecution withheld information on who may or may not have been an informant in the case. The post then solicits money for filing some type of lawsuit, even though Cox is currently being represented by the federal public defender. How dare Schaeffer Cox try to raise money to get his own lawyer? How dare he not be satisfied with the federal government provided federal public defender? Exhibit number 9. The FBI ambushes innocent man, American political prisoner, Schaeffer Cox. July the 23rd, 2013. This post is 15-page denial of any wrongdoing and a repeat of Cox's trial themes and testimony at trial. Footnote number 2, bottom of page 8. Cox or his followers sent brochures to to the public claiming various wrongdoings and seeking funds. The Office of the U.S. Attorney received more than 100 of these brochures, signed and unsigned, mostly from the elderly, seeking Cox's release. How much money Cox received from this solicitation is unknown. See Exhibit 27, attached here to No Smoking Gun, the federal framing of Schaeffer Cox. Exhibit 10, U.S. Government Fears, Zombies, Resistance, and Truth, January the 8th, 2018. In this post, among other things, Cox solicits readers to getting big names and celebrities support his case and speak out against the prosecution. If you can get some big names to talk about my case and ridicule its architects, Obama, Holder, Bottini, Scrocky, it will crumble. Exhibit number 11, Hit List. The Post claims the hit list is not real. August the 27th, 2017. Exhibit 12, I just got some big news. May the 29th, 2018. This post comments about the U.S. Supreme Court reviewing his case. But again, Cox denies guilt or responsibility. Exhibit 13, it is torture. Please help me. May the 30th, 2018, Cox complains, among other things, about not being on the Freedom Coalition's pardon list to the President of the United States, claiming he's in prison for a hypothetical crime in an imaginary future. Exhibit 14, Let Freedom Ring, September the 18th, 2018, Cox announces a defense team for an open civil cases and alleges discovery was withheld from him prior to trial. He then solicits funds for his legal defense fund via PayPal. Exhibit 15, Message from America's Black Site Prison, September the 2nd, 2017. This post is similar to others, but threatens readers of a much larger scale of a government crackdown on individuals. After writing about the erosion of the United States in general and the impending crackdown, Cox asked for $50 or $100 contribution. Exhibit 16, Highly Organized Persecution of Christians. November the 7th, 2017. In a limited part, these sections of the blog stands out. Quote, and this is all from some sort of flyer that a Schaeffer Cox supporter put out, and I'm not sure how they can get away with holding this against Schaeffer, as it appears a supporter put this out. But it reads, after I was arrested, they put me in solitary confinement, sleep deprived me for days on end, then told me that my family was ashamed of me and wouldn't speak to me until I signed a confession against myself. So all this would be put to bed and stop more mud from coming out. It was all lies. It was all a trick. It was a trick. My family was camped out on the jail steps saying this was crazy and I was innocent, but I didn't know it. Fulton and these same handlers are still at work dreaming up ways to spook off anyone who would support me, and they are still raping the daylights out of Alaska Native Eskimo toddlers at their power parties in Anchorage. They moved it from the Ocean View house, but they didn't stop. Exhibit 17, Department of Justice prosecutor has the same compulsions as a serial killer. May the 22nd, 2017. This post is directed at AUSA Joseph Bottini and likens him to having the same compulsions as a serial killer. Exhibit 18, The Taste of Bad News, November the 8th, 2017. This post comments about the Ninth Circuit ruling resulting in this sentencing remand and extensive claims of innocence. Exhibit 19, Scrocky and Caligula, July 3rd, 2017. In this post, the undersigned is compared with the Roman Emperor Caligula in deeds and in writings. Exhibit 20, Hero Blood, September the 30th, 2017. Cox seeks from others in this post assistance in garnering celebrity endorsement of his cause. Exhibit 21, Spin Doctors, August 19th, 2019. In this post, the FBI special agent assigned to the case is spotlighted vis-a-vis Cox's innocence. Exhibit 22, The Deeper the Love, the Deeper the Pain, April the 11th, 2018. Cox complains of having communication improperly or illegally blocked with one of his supporters. I wonder who that would be. Exhibit 23, It's like Caveman Court, March the 5th, 2017. This post shows a picture of Cox prior to arrest staring at a notice on a glass door that prohibits firearms inside the building. The post concerns itself with the government's appeal brief and this court's ruling on the Rule 29 argument concerning the solicitation charge. Exhibit 24, You Just Never Know, June 16th, 2018. This post can be summarized as follows. And then it has something that appears as if it was written in Schaeffer Cox's handwriting, but a lot of times I know people that support Schaeffer and they use programs to make it look like Schaeffer Cox wrote it, but he didn't really write it. Let me tell you what. I've been mistreated about as bad as anyone can be, so I'm sure my case is in the top 1,000 most unfair cases, maybe even in the top 40, and we have the proof, which means you guys out there can literally tweet me out of prison right now if you boil down the message and push it hard enough at a single concentrated target, like Trump or someone close to him. Please go familiarize yourselves with the facts of my case by reading freeschaeffer.com and by watching the many videos about my case on YouTube. Then blast our president and his staff with request for a pardon, focusing on the unfairness of it all. Exhibit 25. Your life depends on it, September the 3rd, 2017. Among other things, this post warns of pending government crackdown on citizens like the others. Cox claims he is a victim of government oppression and criminal activity. Exhibit 27. Free Schaeffer Cox brochure sent to the U.S. Attorney's Office. Part D, resentencing arguments by Cox on Count 1, conspiracy to murder federal officials. A, facts. The facts from trial as to Count 1 of the indictment are adequately but in general covered at page 4 of the addendum to the pre-sentence report, page 4. The United States adopts that response and incorporates it by reference to this memorandum. The United States also relies upon the facts provided in its answering brief on appeal. See United States answering brief, case 13-30,000, docket 121, pages 5 through 51. Attached hereto as Exhibit 26 for the court and parties' convenience. The defense has provided the court with several transcripts with selected excerpts, none new, of Cox and confidential human sources, Fulton and Olson. What has been provided to the court are snippets casting blame and, in reality, innocence on Cox under the guise this whole prosecution was at the behest of these two men. Point. Cox started his speech circuit before ever meeting the confidential human sources. Point. His machine gun, silencer, and grenade-making activities occurred independent of and prior to meeting the confidential human sources. Point. The CDs found in his home on poisons, full auto conversions of various rifles, creation of explosives, and other illegal activities were in Cox's possession without knowledge of, nor at the urging nor provision of Fulton or Olson. At trial, Cox dismissed the CDs as spam that somebody had left on his desk. Footnote number 4 at the bottom of page 12. All citations in the United States answering brief cite to the trial record in this case. The facts at trial were clear that Cox stated that in the event of his or a militia member's capture, that the 2-for-1 plan would be put into effect. Cox was also clear that in the event he or a member of his family was arrested again, there was an arrest warrant pending for his arrest. That arrest would also trigger a violent response. See United States answering brief, case 13-30,000, docket 121, pages 12 through 13, comma 2. Point. In furtherance of the arming of himself, his lieutenant Coleman Barney, and members Lonnie and Karen Vernon, Cox was arrested purchasing silencers and what he believed to be 2 hand grenades. Point. Cox, as has been argued time and time again, was predisposed to not only acquiring silencers and grenades, but was looking for C4 explosive. Cox sent Olson and Lonnie Vernon to the militia convention with the express purpose of acquiring them. See answering brief, case 13-30,000, docket 121, pages 20 through 24. Point. The idea for a hit list with Mike Anderson came from Cox and nobody else. Cox provided Anderson with the names of state and federal officials for the list, and the two drew a map of the U.S. courthouse in Fairbanks as part of the discussion. Based on this, Anderson began research on his own, including locating U.S. Marshal Jimmy Johnson on his own. Anderson, for his part, was so worried about Cox that he destroyed the database. What information it contained will never be known. What is known is that Cox wanted the database and made great effort while on the lam to locate it. That's not true, and was the one who provided Cox with specific names of state and federal officials to begin the database. Let me read that sentence again, because that didn't quite flow well with honesty. What is known is that Cox wanted the database and made great effort while on the lam to locate it. That is not true. And was the one who provided Cox. What, Cox is the one who provided Cox? The whole sentence doesn't make any sense, because he's saying that Cox is the one who provided Cox with specific names of state and federal officials to begin the database. These so-called fancy Ivy League prosecutors don't even know how to construct a sentence. Cox wanted access to the database before fleeing. No, I think that came from Gerald J.R. Olson. Lonnie Vernon wanted access to the database as well. Exhibit 26, page 35. Cox spent hours with Olson trying to locate Anderson to get the list. IBID, page 36. Even if Cox's tale of leaving the state it was to be believed, well, we'll never know, because they stopped him and they tried to kill him. Cox took with him his machine gun and ammunition, his silencer for his .22, and grenade components and parts, along with him his grenade launcher, hornet's nest parts, and pieces for his semi-automatic rifle. Point. Cox discussed with Olson how a silencer would work, that he wanted to stock up with grenades if the cost would be below $70 each. I would be feeling like I can buy as much as I want. Exhibit 26 at page 33. None of this was at the urging of Olson. Cox also explained to Olson how to use a bolt and a 2-part adhesive to plug the hole in the 17 grenade bodies found in his trailer so they could be used as real grenades. Some items were found in Cox's trailer the day of his arrest. J.B. Weld, reloading power, grenade fuses. He should put spent grenade fuses, not grenade fuses. That's inappropriate. And 17 grenade bodies. How about call them what they are? 17 dummy grenade bodies. You can buy them at any Army Navy store down here in Texas anytime. On the day of his arrest, Cox opined that in the context of having to purchase a .22 with a silencer, but see, even at close range, they take a long time to die. Coleman Barney was not different, asking, how are they for devastation? Pretty good? Exhibit 26, page 37. The following checklist establishes that Cox was not waiting for some futuristic Stalin-esque takeover to occur. In Cox's mind, which is what matters, that day had already arrived, save for 2 items. Acts of war. Number 1, firearm restrictions or other disarmament. Number 2, declaration of martial law. 3, mandatory medical anything. Unchecked. So 1 and 2 were checked. 3 is unchecked. 4, checked. Involuntary involvement in anything. 5, checked. Circumvention of juries. 6, checked. Confiscation of any property. 7, unchecked. Elimination of gold, cash, or barter. 8, checked. Checkpoints of any kind. 9, check federal patrols. 10, check blockades or restrictions of essential goods. 11, check political arrest. 12, checked suspension of courts. 13, unchecked chips or marks. 14, checked child control. 15, checked federalization of law enforcement. 16, checked restrictions on freedom of religion or speech. 17, checked surrenders powers to a corporation or federal foreign government. See out below are photographs of some of the items seized from Cox's trailer. The .30 caliber hand-cranked Browning machine gun, the fully automatic Sten machine gun, grenade bodies, and other items. They need to mention that the grenade bodies were dummy grenades. The Sten machine gun did not work, and it's just insanity. And then they show pictures. They show pictures of the dummy grenades, the Sten machine gun that did not work, and parts of other firearms and a revolver. And they're all painted black, and they look very scary. So I'm sure this is supposed to induce terror in the eyes of the Ninth Circuit judges who are going to look at these pictures. He's also got pictures of ammunition and clips, and looks like a picture of a AR-15 with clips with ammo in it. These aren't the tools of a defensive prepper, but are instead offensive weapons and weaponry which Cox actively sought, independent of Fulton or Olson, and are possessed well before meeting Fulton or Olson. Nevertheless, as set out below, Cox maintains this case is an outlier, warranting a reduction in sentence for that and other reasons. The memorandum opinion of the Ninth Circuit found, however, that the conspiracy to murder charge itself, standing alone, was sufficient for conviction and not evidence as to the numbers of individuals on the Cox-Anderson hit list or other targets, nor timing was necessary. Part E. The agreement standing alone constituted a sufficient threat to the safety of a federal officer as to give rise to federal jurisdiction. Thus, sentencing is not limited to Cox and Anderson's list and databases. Cox complains that the conviction for count 1 is an outlier and cites to various authorities in support of this claim. This case, however, is no outlier. More to the point, Cox repeatedly states that the list was Anderson's list. Factually, this is incorrect. It was Cox who gave to Anderson all the names on the list. Anderson had no idea as to whom these individuals were. Cox did, however, and knew of them because they were simply government employees, or even a family friend like Tina Bucamp, who made the mistake of not giving Cox information as to whether or not he was on a no-fly list. To say this was Anderson's list is factually incorrect. Cox sought out and utilized Anderson's skills for his own needs. Anderson did not independently arrive at this project. It was only done at the urging of Cox, as stated by the Ninth Circuit. Defendant next challenges the sufficiency of the evidence on the conspiracy charge. We assume, without deciding, that defendant has properly preserved this challenge, so that our review is de novo. See United States v. Phillips, 704F.3D, 754, 762, Ninth Circuit, 2012. We conclude that, quote, considering the evidence presented at trial in the light of most favorable to the prosecution, that evidence so viewed is adequate to allow any rational trier of fact to find the essential elements of the crime beyond a reasonable doubt. United States v. Niels, 598F.3D, 1158, 1164, Ninth Circuit, 2010 in Bonk. Internal quotation marks and alteration omitted. Defendant and his co-conspirators agreed to attack government officials, including federal officials, including federal officers, in the event of certain conditions that they subjectively thought were likely to occur. A rational trier of fact could find beyond a reasonable doubt that the agreement was not merely one for self-defense. A rational trier of fact could also conclude that the agreement standing alone constituted a sufficient threat to the safety of a federal officer so as to give rise to federal jurisdiction. United States v. Fiola, 420 U.S. 671, 695-96, 95, Supreme Court 1255, 43 L.ed 2D 541, 1975. What matters here is not what might happen, but what Cox thought might happen, along with the agreement standing alone constituted a threat to the safety of federal officials. As was discussed at trial again several times, was Cox's belief in his pending arrest, the arrest of one of his family, removal of his son by OCS, or capture of one of his militia members was pending and pending soon. The facts of the cases cited by Cox are all distinguishable when viewed in this light. Part F. Imperfect sentencing entrapment. A. For every Gandhi, there was "I'm not against sending heads in boxes." Cox's entire sentencing brief, including the report of Dr. Cunningham, is tactically filed for the purpose of sentencing reduction for imperfect entrapment. The reduction, however, should not be awarded to Cox for several reasons. The United States starts with the McClelland case itself. In United States versus McClelland, the defense sought and received a sentencing departure where entrapment was rejected at trial. The United States appealed, claiming such a departure was not available where the defendant initiated the criminal activity. The Ninth Circuit disagreed. United States versus McClelland, 72 F.3D 717, 725, Ninth Circuit, 1995. In fact, evidence of imperfect entrapment, like evidence of imperfect coercion, is in some cases a legitimate ground for departure because it may show that the defendant is both less morally blameworthy than an enthusiastic defendant and less likely to commit other crimes if not incarcerated. See Garza-Juarez 992 F.2D at 913N 1, quoting with approval Dickey 924 F.2D at 840 Reinhardt J. dissenting. A district court could properly determine that a defendant who first proposed an illegal scheme but who later expressed serious reservations and acted only after strong and repeated inducements by the government is less morally blameworthy and less likely to commit crimes in the future than a defendant who eagerly participated in an illegal scheme with no inducement other than the initial suggestion by a government agent. Thus, if a district court departs downward on the ground of imperfect entrapment in a case in which the defendant first approached the government, the departure may still be completely consistent with at least two important factors relevant to sentencing protection of the public and characteristics, particularly to the defendant's culpability. See Pacheco-Osuna 23 F.3D at 271-72, Garza-Juarez 992 F.2D at 913N1. In this investigation, Cox did not approach the United States. The United States approached him due to his statements about possessing illegal weaponry and other activities. The investigation revealed that Cox was predisposed to have and did have illegal weaponry well in advance of any government contact. Not only that, he wanted more on his own volition, including C4 explosive and hand grenades. Cox was predisposed and wanted more without any government incentive. The very most the defense can point to are statements by Fulton and Olson, in essence asking for information about Cox's plan. This investigative technique is not instigation nor inducement. That is crazy. That is an outright lie. As someone who has gone through hours and hundreds of hours of this case, there is multiple times that Gerald J.R. Olson was provocative and prodding Schaeffer Cox over and over and over again. Schaeffer, what are we going to do if they come for you? Schaeffer, what are we going to do if you get put in jail? Schaeffer, what are we going to do if they go for your kids, if they go for your wife? Bill Fulton, I'm going to slit your throat and bleed you out at his feet, was said to Les Zerby, and later it was said, go remember Schaeffer Cox about the time I almost killed Les. I mean, there is over and over again provocations by the FBI informants, and yet Scrocky is a bold enough liar to lie to the judge to say this investigative technique is not instigation nor inducement. In fact, the activity, this is going on and continuing to read this document from Children of the Devil. In fact, the activities and statements of Cox and Vernon were terrifying to law enforcement, particularly due to the fact that Cox, who had a warrant outstanding for his arrest, could have been arrested at any time. The same holds true of the Vernons, who were in fact arrested with a map to Judge Beesline's home, members of his family's home, and more than a dozen goodbye letters, along with assault rifles and ammunition. These men were so dangerous that the FBI posted to law enforcement a do not arrest notice due to them being armed and the statements they were making. While Cox over and over states that a plan was an instigation of the government, the record is devoid of any pushing for action, only for information for law enforcement protection of those targeted. While this is clearly a fine line, it is an important one and an important distinction. Neither Fulton nor Olson urged Cox to go operational, start killing people or otherwise. Wow! How about we put in there Fulton threatened Schaeffer Cox's life and Olson urged a 541 plan? They asked Cox when, in effect, he was going to do so. For every answer by Cox of a Gandhi, there were answers by him, Vernon or Coleman Barney, about targeting police officers, killing government employees, judges, and collecting data on them in the event of his arrest or the arrest of others. The facts remove any claim under McClelland and Cox is deserved of a downward departure for imperfect entrapment. Cox never once, not once, retracted 241 in the event of his arrest or an arrest of his family, a militia member, or if his son was taken by OCS. There was no aggressive encouragement to take action, only to provide information. The facts of this case are far removed from those in McClelland. Cox's plan clearly stated was that in the event of his arrest, 241 would be triggered. This was his order. Isn't it amazing that Cox is in a communication restriction so the prosecution can say all of this garbage and we're not allowed to mail this to Schaeffer anymore and get Schaeffer's response? Isn't that amazing? I just think it's amazing that the prosecution is allowed to put out this garbage and we're not allowed to mail it to Schaeffer and say, Schaeffer, what's your response to this? That's very convenient. Hey, it's very convenient to stick an innocent man in prison who you threaten to kill and then put out a bunch of garbage about him right before he gets resentenced and then to block all of his letters. And to block my communication for over a year. Isn't that convenient? This was his order and done at his urging, not at the urging of Fulton or Olson. McClelland based its rationale for the perfect entrapment departure on the very clear premise that a district court could properly determine that a defendant who first proposed an illegal scheme, but who later expressed serious reservations and acted only after strong and repeated inducements by the government, is less morally blameworthy and less likely to commit crimes in the future than a defendant who eagerly participated in an illegal scheme with no inducement other than the initial suggestion by a government agent. McClelland 72 F.3d at 726. In a footnote, the court noted that in deciding whether a departure is warranted on the ground of imperfect entrapment, the amount of inducement, the level of reluctance on the defendant's part, and who acted first should all be factors for the district court to weigh, i.d. Here, taking the elements in reverse order, Cox clearly acted first, by and in all accounts, with his level of reluctance. His level of reluctance was slim to none, and the amount of inducement as to action was limited to nil. Inducement as to what the plans were, yes, taking action, lacking murdering a spouse, as in McClelland, no. The only reason Cox showed any reluctance was not due to being timid, lacking in intent or general reluctance, but only because he and his militia, in terms of general takeover strength, were not yet strong enough to prevail. Hence the attempted purchase of silenced pistols and grenades to further those aims. One more point requires mention. In an abundance of caution, the United States took the unusual step of releasing its own email assessments of Cox's timeline and discovery. This was done as the reporting of investigative activity to the United States Attorney as a briefing did reveal that Cox had no timetable for his uprising outside of his possible arrest. However, the emails were focused on not only the Cox case, but the Vernon's case, and planned to murder Judge Beesline and his family, a crime occurring parallel to all of Cox's activity. Not only that, the emails were based on a limited review at the time of Cox's recording, usually made the night before. Thus, they were not a full and complete review of what was actually said, but were informationally only for the United States Attorney. The United States stands behind the email's content and disclosed them based on its assessment of the timeline of Cox's plan to murder state judges and other law enforcement members, and Vernon's plan to murder Judge Beesline and his family. First of all, I don't think that Lonnie Vernon and Karen Vernon were planning to murder Judge Beesline, but let's just for a fact, what Lonnie Vernon and Karen Vernon were planning to do had nothing to do with Schaeffer Cox. So isn't it convenient that Scrocky continues to bring that up? I mean, we can't get Schaeffer Cox on his own crime, so let's keep bringing up what Lonnie Vernon and Karen Vernon were charged with. Here, nobody in this case said, hey, let's all call this off. Let's call this off and let's not do this. In fact, it was the opposite. We'd like to do it, but when? What's the point of Stephen Scrocky bringing up Lonnie Vernon and Karen Vernon all the time? True, Cox never formally had a timetable to independently murder State Court Judge McConaughey or other members of the judiciary, but the emails do nothing to contradict the clear facts that if Cox was arrested pursuant to the outstanding state warrant, his orders for 241 were in clear effect. The report of Dr. Cunningham. The defense has filed in aid of sentencing the report of a second psychiatrist, Dr. Mark Cunningham. Dr. Cunningham's report contradicts an early report provided by Dr. Robin Leroux, which Dr. Cunningham finds as incorrect. The court therefore has before it competing reports by two medical professionals. Dr. Cunningham's report is extensive, but does not, in the government's view, really provide anything new. To wit, point, it is no surprise that the defendant was physically and verbally abusive to his spouse. This was known by the investigation. Point, it was no surprise that the defendant exaggerates, misrepresents, lies, and fabricates his own deeds, facts, and enjoyed being the center of attention. Point, it is no surprise that Cox harbors features of narcissism, as stated by Dr. Cunningham. Point, that he possesses socially confident oratory skills. The United States agrees, and that those skills were put in great effect in talks across the western United States, in Fairbanks, Alaska, and to members of his militia. It continues to this day with his blog post on his current legal predicament. Other findings such as thinking errors and deficits in critical thinking, emotional overreactivity, high initiative but deficient perseverance have no bearing on the sentence to be imposed in this case. Moreover, Dr. Cunningham's conclusion that Cox's likelihood of committing acts of violence upon release is very low ignores the basic tenet of this case. It is not Cox doing the violence. It is Cox's words, arguments, instigations, and manipulations of others to do his bidding, which is the greatest cause of concern. Facts in this case are legion that Cox was able to convene dozens to hold a fake trial exonerating him from choking his wife. Schaeffer is not guilty of physically abusing his wife. That's the most insane thing in the world. He was able to enlist dozens to march on the Fairbanks courthouse in support of his defiance of a state court judge, whom he threatened, and in the process threatened a state trooper as well. These threats, of course, were made with dozens behind his back in support. None were made alone. He was able to muster more than half a dozen for a security detail at radio station King James North Pole, dressed in body armor, armed with anti-riot grenade launchers, semi-automatic rifles, all to face an unknown federal hit squad. Such was the power of his convincing that independent checklists, plans, routes, and other logistics were arranged, all to protect Cox. If that weren't enough, Cox, apparently intent on leaving Alaska, or so he says, took his armaments with him: a crank 30 caliber machine gun, a 22 with a homemade suppressor attached, a fully automatic machine gun, grenade components and parts, handcuffs, ammunition, a semi-automatic rifle, and other implements. Cox held these items dear enough that they were not left behind, but saved, as they constituted the beginnings of his weapons cache to be used when needed by him. Of course, during trial, Cox took the stand and denied everything, from the Sten gun not working, to not wanting grenades, to having no idea how information on explosives and full auto conversion manuals landed on his desk, and that a hit list reference found on his iPhone meant a music list. Dr. Cunningham does an extensive amount of work attempting to explain Cox's behavior and actions away, but they are belied by the fact of the investigation and the facts of the trial. Moreover, Dr. Cunningham's report takes steps and opines about Cox's actions, which are very much belied by the facts. Two examples are provided here. Mr. Cox's mood disorder, anxiety disorder, and personality maladjustments rendered him particularly vulnerable to the fear-inducing interactions with a government informant and the facilitation of the information in procuring hand grenades. In the absence of these government-sponsored influences, it is improbable that Mr. Cox would have engaged in some of the offense conduct. Cunningham, report page 33. Let's set the record straight on this statement. Cox would have continued on this path without government-sponsored influences. They made a typo. We found a typo in Scrocky and Brian Schroeder's resentencing memorandum. Let me see what page this is. This appears to be page 26. It should be with or without, but they put with our, without, A-U-R. Terrible, terrible grammatical error on the part of Stephen Scrocky and Brian Schroeder. This so as Cox had been predisposed for years and wanted more without government urging. The idea for more grenades and C4 were his and his alone. Additionally, Cox made a .22 silencer himself before ever meeting Olson or Fulton. The same holds true about the Sten machine gun. Cox showed Barney how the silencer worked outside of any influence of Olson or Fulton. Hey, God forbid that a man in the United States be interested in firearms. God forbid they be interested in firearms and think it's really cool to have a bunch of firearms. In Texas, you know what you call a neighbor with 50 firearms? Let me ask you that question. I got a question for everybody listening. What do you call a neighbor with 50 firearms? You call him a good neighbor. And you say you need some more firearms. Okay, the idea. Okay, let me see. Cox made a .22 silencer himself before ever meeting Olson or Fulton. The same holds true about the Sten machine gun. Cox showed Barney how the silencer worked outside of any influence of Olson or Fulton. Cox had his own grenade pieces and parts and fuses. It should say spent fuses, obtained from Aaron Bennett, totally outside any influence or knowledge of Fulton and Olson, as was established at trial. Cox and Barney practiced with dummy grenades outside the presence or even the knowledge of Olson or Fulton. God forbid that you or I go out and do things without the knowledge of FBI informants. God forbid that you or I have any plans to do any activities outside of the purview and the knowledge of FBI snitches. Cox, on recording, instructed Olson and Vernon to get as many grenades as possible at the militia convention in Anchorage. For added measure, Cox, on his own, asked the men to look into getting C4. Barney, on his own, mentioned speaking to an arms dealer. These are just a few of the facts which make Dr. Cunningham's report meaningless. In summary, it is nothing more than a results-oriented exercise which contradicts an earlier report by another qualified mental health professional. So, which one is correct? In this circumstance, this report does nothing but justify Cox's actions based on a lack of socialization upbringing, having no limits, and then concludes by adopting Cox's own mantra about this case. None of this was his fault, or if it was, it can be explained away for reasons not attributed to him. The facts of the trial belie that conclusion. Another example is as follows. Mr. Cox was not regarded as a serious threat of violence, whether personally, perpetrated or inspired by case agents in the months prior to his arrest. Cunningham Report, page 33. This is flatly untrue. In the months leading to his arrest, this case was being investigated and monitored almost 24/7, and had been for months. This statement, given all of the evidence adduced at trial and discovered from the investigation about murdering judges, killing children, acquiring C4, grenades, silencers, shooting hornets' nest around in people's homes and shooting them as they came out by Cox, Vernon, and Barney, and others, is shockingly inaccurate. This issue was and is not when an external act would occur, but what Cox thought and expressed in the now if he was arrested, or a Barney or Vernon was arrested, or his child taken by OCS. These trigger points were real for the investigation and could have happened at any time. Far from being a prepper, Cox was an instigator who advocated violence and the arming of citizenry against an allegedly oppressive government for his own purposes and sense of self-aggrandizement. While Cox may not have ultimately been the one to use violence, he was perfectly happy to have others around him who he would instigate, cajole, and or talk into using violence. Lonnie Vernon is a prime example of that. The United States reserves the remainder of any commentary on Dr. Cunningham's report and the sentence to be imposed for the sentencing until after Dr. Cunningham testifies. Conclusion. There is no imperfect entrapment here. Cox's desire for weapons of lethality, silencers, grenades, C4, and other equipment possessed for his shadow, Ward Dispatch that argument. While the defense made a significant effort to reduce Cox's sentence, it has done so by selective quotes, emails, and snippets of recordings from a months-long investigation. Cox's own statements during the investigation contradict this repeated argument. Dr. Cunningham's report does not tell this court anything new other than opining that none of this is Cox's fault and he is a non-violent individual. While there may be some shred of evidence to support that conclusion, the fact remains that Cox surrounded himself with those that would and did believe in him and do his bidding. This makes him the leader removed, but the leader in charge of those willing to serve under him. Cox, more importantly, could have ended his diatribes against the government at any time. God forbid that anybody should have a diatribe against the government, yet he chose and elected not to do so. He continues to do so up to this day and has done nothing to alter the court's prior views and comments. The sentence should remain unchanged. Respectfully submitted, October the 21st, 2019 at Anchorage, Alaska. Brian Schroeder, United States Attorney. Stephen E. Scrocky, Assistant U.S. Attorney, United States of America. Certificate of Service. I hereby certify that on October the 21st, 2019, a true and correct copy of the foregoing was served on the following electronically: Michael Filipovic, Stephen E. Scrocky, Office of the United States Attorney. Footnote number 5 at the bottom of page 29. This brief is lengthy due to the size of the case and the issues presented by Cox. Ordinarily, the United States would include an analysis of the 18 U.S.C. Section 2253 factors. As to those factors, the United States relies on and adopts those provided to the court as if fully set forth herein and as stated at docket 550. Wow, what a bunch of hogwash from the Department of Justice, who are children of the devil and are continuing to double down on their efforts to keep Schaeffer Cox in prison as long as they can. Isn't it amazing that Schaeffer Cox has been put in a special prison where his communications have been restricted, and even with his restricted communications, they're still afraid of his blog spot and any communication that he does manage to get out. Imagine if Schaeffer Cox was in an unrestricted prison where he could make phone calls freely to the outside world or put letters that he could mail to his friends and family that weren't previewed and restricted and trashed, as in the case of my wife and I, who have been prohibited from talking to him for over a year. Imagine if he wasn't operating under the threat of Muslims beheading his friends, Robert David Neal, and he wasn't 4-point shackled and had scurvy and suffering torturous issues within a hellhole prison that is not even legal. You heard me right. The CMU in Marion, Illinois and Terre Haute, Indiana are illegal. They were put together without the proper oversight and funding of Congress. There is a letter from Congress to the BOP and the DOJ stating that, and I have that letter. But you have been read the 29 pages by Stephen Scrocky and Brian Schroeder. You can download this document from Year of Jubilee, Jubilee spelled with one E.com, or you can go to IHateTheFBI.com, because they are doubling down on their persecution of Schaeffer Cox. Because if they allow themselves to admit the truth, they will admit their whole career is a lie. That Bill Fulton is a scumbag who threatened the life of Les Zerbe and Schaeffer Cox, that they destroyed evidence, that the BOP allowed and encouraged the murder of Robert David Neal, and that they have put innocent men in prison, including we have a mysterious death of Senator Ted Stevens. And we know that they withheld exculpatory evidence in the case of Ted Stevens, and they were never punished properly for it. And we have the CEO, Bill Allen, of Vico Oil Company, who was allegedly having sex with underage girls, and the Department of Justice made a deal with him to get fabricated testimony to get a false conviction on Ted Stevens. None of that is talked about in these 29 pages. They're doubling down on their prosecution and persecution of Schaeffer Cox. Now, the challenge is that it's the same judge where they persecuted Schaeffer Cox the first time, Judge Robert Bryan. What do you think the odds are that Schaeffer's going to get a fair trial with exactly the same retired judge who's hard of hearing, who knows how old he is now? Who knows how senile this old judge is? Do you think this old judge is going to side with Schaeffer and go against the establishment and call into question the careers of Karen Loeffler, Yvonne Lamouret, Stephen Scrocky, Joseph Bottini, call into question the career of the FBI Special Agent Rick Sutherland, call into question the actions of the FBI when they perpetrated death threats upon Schaeffer and Les Zerbe with Bill Fulton and Gerald J.R. Olson? Do you think this judge is going to have enough courage to call into question all of that to set Schaeffer Cox free? The evidence shows he was leaving the state, even though Scrocky tries to deny that in these 29 pages. I pray that you read this yourself. This is a horrific miscarriage of justice. These two men are children of the devil, and God Almighty will not be mocked. Justice will rain down like a mighty river, and I believe the FBI should be dismantled and should be ridiculed throughout all of our history, that this organization was allowed to get away with this kind of activity, and the Department of Justice should be dismantled as well. These people are absolutely and thoroughly wicked. Thank you for your time.